quick, but all right. 216. Blank means any person charged in indictment or Superior Court information with a Class B, C, D, or E felony.
Eligible defendant.
A defendant is not eligible if he is within the proceeding how many years, excluding the time offender was incarcerated between the commission of the previous felony and commission of the present felony, had been previously convicted of a violent felony offense or any other offense with which a maritime allowance is not available, a Class A felony offense, been previously adjudicated a second violent felony offender, or been previously adjudicated a persistent violent felony offender. How many years within the proceeding? How many years?
10 years.
Right. Blank is a written assessment and report by the court, approved entity or licensed healthcare professional experienced in the treatment of alcohol and substance abuse, or an addiction and substance abuse counselor credentialed by the Office of Alcoholism and Abuse Services for the Mental Hygiene Law.
God. Is it risk assess? No, I don't remember.
Close though, you're in the right realm. It's an alcohol and substance abuse evaluation.
Fuck, okay, the risk assessment is the YO and the JO.
Yeah, that's in 722. 416. Alcohol and substance abuse evaluation shall include the following. Evaluation if the defendant had a history of alcohol or substance abuse or dependence. Recommendation whether defendant's alcohol substance abuse could effectively be addressed. Recommendation as to the treatment mode, level of care, or length of treatment. Any other information, factors, circumstances, or recommendation deemed relevant. At any time, that was just all of the above.
Okay,
Your hair looks so amazing.
Oh, you could see it?
Oh my god, it looks amazing.
Wow, thank you.
Oh my god, it's down to your butt.
Yeah, it's really long. It's a little puffy right now.
And it's so thick. I'm so jealous. I'm taking vitamins and everything. My hair's just not growing.
Yeah, you gotta give it time. Mine didn't just grow like immediately.
Yeah. Alright, next question. At any time after arraignment of an eligible defendant, but prior to the entry of a plea of guilty or commencement of a trial, the court, at the request of who, may order alcohol and substance abuse evaluation.
The eligible defendant.
Right. An eligible defendant may or may not decline to participate in the evaluation.
He may decline.
Right. The defendant shall provide a written authorization authorizing disclosure of results of an assessment, and who are those people that is authorized disclosure of the assessment?
It's a long list. I don't know if I'm going to be able to name all of them.
I'll just name them.
But I'm hoping if I put... Yeah, just name them.
The defendant's attorney, the prosecutor, the local probation department, the court, authorized court personnel, and other individuals specified in such authorization. Anybody that... oh no, that's wrong. I just stuck that in. Anybody requests to see it. For the sole purpose of determining whether the defendant should be offered judicial diversion for treatment or substance abuse, counsel abuse, or dependence, and any co-occurring mental disorder or mental illness. And upon receipt of the completed alcohol and substance abuse evaluation report, the court shall provide a copy of the report to who?
The prosecutor, the defendant's counsel,
That's it.
That's it?
Prosecutor and the eligible defendant.
Okay, so
That's
no probation, no probation.
Nope. So the eligible defendant and the prosecutor will get, upon receipt of the completed alcohol and substance abuse evaluation report, the court shall provide a copy. So the only people that get a copy is the prosecutor and the eligible defendant.
Alright, so no probation there.
Nope.
Alright.
And that's a copy of the alcohol and substance abuse evaluation report. Upon receipt of the evaluation report, either party may request a hearing on the issue of whether eligible should be offered alcohol and substance abuse treatment, At such proceeding shall be held when?
Oh my God. I don't know. Just say it.
It's as soon as practicable as to facilitate early intervention in event that defendant is found to need treatment.
You know what sucks? We knew this and I forgot it.
I remembered it when I read it. And the court may or must consider oral or written arguments.
May.
And the court may or must take testimony.
May.
The court may or must consider any relevant evidence, including evidence that the defendant had within the preceding 10 years, excluding the time that he was incarcerated for something else, for a violent felony or any offense with the maritime allowance is not available, or in the case of a felony defined in 41091, any statement or submitted by a victim.
It's a may.
Right. Upon completion of the hearing on issue of whether the eligible defendant should be offered treatment, the court shall consider and make a finding of facts with respect to whether A, the defendant is an eligible defendant, B, the defendant has a history of alcohol or substance abuse dependency, C, such alcohol or substance abuse is the controlling factor to the criminal behavior, D, the defendant's participation in judicial diversion could effectively address the abuse, E, confinement of the defendant is or may not be necessary for the protection of the public, and F, the defendant is just a hopeless case and nothing is going to help him. It's all the other ones.
It's the first five.
Okay. If court determines the eligible defendant should be offered alcohol and substance abuse treatment, or when the parties in the court agreed to the eligible defendant participating in treatment, an eligible defendant may be allowed to participate in judicial diversion program prior to the court issuing an order granting judicial diversion. The eligible defendant shall be required to enter a plea of what to the charge?
Guilty.
Provided, however, no such guilty plea shall be required when the people in the court consent to the entry of such order without a plea of guilty, or, based on finding of exceptional circumstances, the court determines that the plea of guilty shall not be required.
Alright, can you just do me a favor and say the thing about the as soon as practicable thing again so it's on the video twice?
Sure, you ready?
Yeah.
Upon receipt of the evaluation report, either party may request a hearing on the issue of whether the eligible defendant should be offered alcohol or substance abuse treatment. At such proceedings shall be held as soon as practicable as to facilitate early intervention in the event that the defendant is found to need treatment.
Alright, thank you.
No problem. Next one is, exceptional circumstances exist when, regardless of the ultimate disposition of the case, the entry plea of guilty is likely to result in what?
Serious collateral consequences?
Severe collateral consequences.
Severe, okay, almost had it.
Good. Defendant shall agree on the record or in writing to abide by release conditions set by the court. Conditions shall include participation in a specified period of alcohol or substance abuse treatment, which may include A, periods of detoxification, B, residential or outpatient treatment, C, periodic urinalysis.
It has to be, the first one is a must, and then the other three are may include.
If the court shall include periods of detoxification and residential or outpatient treatment, and conditions may include periodic appearances, which may include urinalysis, requirement that the defendant refrain from engaging in criminal behavior, and if treatment is for opioid abuse, he may participate and receive medically prescribed drugs. No court shall require the use of any specified drug or brand drugs during treatments. And upon an eligible defendant's agreement to abide by the conditions set by the court shall issue a what?
Is it an order of conditions?
It's a securing order.
Fuck! Okay, oh god, I hate this article.
And the securing order shall what?
either release him on his own recognizance, or to the custody of the.
Order in this article does three things.
Okay, wait. I think I know them. It's ROR, make him pay bail, or release him to the custody of the program.
Right.
Okay.
I'm going to make a list of which articles have ROR, what the securing orders are, Right?
Okay.
Right? So we know now Article 216 has a securing order, and that's bail, ROR, or release to, conditioning. Conditioning any release upon agreed conditions. Alright, so we know 216. We have to go back and do ROR on 170, 180, and 190.
I know, and I feel like I just did so bad on this article, but whatever, let's keep going.
Okay. That was the end of this one. Wait, was it? Let me just check. Was that the end of it? Yep, that was the end of this one.
Okay.
Next. 220. This is drugs, right? Oh no, that's penal law. 220. Alright, here goes. Ready?
Ready, I'm just getting ice. Go ahead.
220. The only kinds of pleas which may be entered to an indictment are a defendant may or may not enter a plea of not guilty to the indictment as a matter of right.
True.
The defendant may or may not enter a plea of guilty to the entire indictment as a matter of right.
True.
Right. Except where indictment charges one of the Class A felonies, 220 penal law drug charges, or attempt to commit such Class A felony, then a guilty plea must, for Class A felonies, then the plea of guilty must be, or must include, at least a guilty plea of what?
Drug, it's a B felony?
Right, a B felony. And if the indictment charges a B felony, it has to include what?
A D felony.
Right. The defendant may not enter a plea of guilty to the crime of murder in the first degree, provided, however, that the defendant may enter such plea with both what? Permission of...
it's permission of the court and consent of people.
Right. When the agreed upon sentence is either life in prison without parole,
or another authorized sentence for that crime,
or a Class A felony murder 1. Other than the sentence of life without parole.
Yeah.
The defendant may, both with the permission of the court and consent of the people, enter a plea of not responsible by reason of mental disease or defect. The defendant may, both with permission of the court and consent of the people, enter a plea of not responsible by mental disease or defect to the entire indictment. The district attorney must state to the court, either orally or on the record or in writing, that the people consent to the entry of such plea, and that the people are satisfied that the affirmative defense of lack of criminal responsibility by reason of mental disease or defect would be proven by the defendant at the trial by what?
A preponderance of the evidence.
Yup. Counsel for the defendant must state that, in his opinion, defendant has or doesn't have the capacity to understand the proceeding.
That he has the capacity.
Right. Before accepting a plea of not responsible of reason of mental disease or defect, the court must address the defendant in open court and determine that he understands these 6 things. The nature of the charges to which the plea is offered and the consequences of the plea. That he has the right to plead not guilty. That he has the right to be tried by a jury. The right to assistance of counsel. The right to confront and cross-examine witnesses against him. The right to not be compelled to incriminate himself. That if he pleads not responsible by reason of mental disease or defect, there will be no trial with respect to the charges contained in the indictment, so that by offering such plea, he waives his right to such trial. Also, that if he pleads not responsible by reason of mental disease or defect, the court will ask him questions about the offenses charged in the indictment, and that he will thereby waive his right not to be compelled to incriminate himself. And last, that the acceptance of the plea of not responsible by reason of mental disease or defect is the equivalent of the verdict of not responsible of reason by mental disease or defect after trial. Next, before accepting the plea of not responsible by reason of mental disease or defects, the court must find and state each of the following on the record in detail and not in conclusory terms. A, that it is satisfied that each element of the offense charged in the indictment would be established by what at the trial?
Beyond a reasonable doubt.
Now, why is this beyond a reasonable doubt and the other one was preponderance of the evidence?
Because the other one was talking about an affirmative defense. This is now talking about, did he do it?
Oh, okay. That the the affirmative defense of lack of criminal responsibility by reason of mental disease or defect would be proven by the defendant at the trial by
preponderance.
That the defendant does or doesn't have the capacity to understand the proceedings against him and assist in his defense.
He does.
That such plea by the defendant is knowingly and voluntarily made, and that there is factual basis for the plea, and that the acceptance of such plea is required in the interest of the public and the effective administration of justice. A plea of guilty not embracing the entire indictment is a plea of guilty to what? Part or an entire indictment?
It's part.
A plea of guilty not embracing the entire indictment is a plea of guilty to what the fuck question is this? 8? Part. But the entry and acceptance of a plea of guilty to part of the indictment constitutes what?
A disposition of the entire indictment.
Right. The plea to an indictment other than one against who may be entered orally by the defendant in person. Must be entered orally by the defendant in person.
Corporation.
Except that the plea to an indictment which does not charge a felony may, with permission of the court or consent of the people, be entered by counsel upon submission by him of written authorization by the defendant.
I guess you need both people and...
No, it just says permission of the court.
Oh, so you don't need the people.
10. A plea to an indictment against the corporation must or may be entered by counsel.
Must.
The defendant who is required to enter a plea to an indictment refuses to do so or remains mute. The court must enter a plea of what? To the indictment on his behalf.
Oh, not guilty.
Where the permission of the court and the consent of the people are prerequisite to the entry of the plea of guilty, the court and or the prosecutor must either orally or in writing file with the indictment state the reasons for granting the permission or consenting the entry of the plea of guilty. It's and both of them have to do it.
All right.
But when a sentence is agreed upon by the prosecutor and the defendant as a predicate to the entry of the plea of guilty, it's only the court or the prosecutor must orally, on the record or in writing, filed with the court state the sentence agreed upon as a conditions of the plea. I have a star next to the next two questions.
Okay.
This is going to be repealed September 1st, 2019, so they may not make a question on it. Prior to accepting a defendant's plea of guilty to an indictment or a superior court information or a felony complaint, it's A, indictment, B, superior court information, or C, felony complaint, charging a felony offense, the court must advise the defendant on the record that if the defendant is not a citizen of the United States, the defendant's plea of guilty and the court's acceptance may result in the defendant's deportation. Is it indictment, superior court information, or felony? Or if it's a one or more, or two or three?
It's A and B only.
Right. A defendant who has entered a plea of not guilty to the indictment may, as a matter of right, withdraw such plea at any time before what?
Before commencement of the trial?
Before rendition of verdict.
Oh, fuck.
I know. And enter a plea of guilty to the entire indictment.
Did you know that one?
No, I keep forgetting that one. A defendant who has entered a plea of not guilty to the indictment, both with permission of the court and consent of the people, withdraw such plea at any time before, again,
Rendition of the verdict?
Right. And enter the plea to part of the indictment. At any time before blank, the court may permit the defendant who has entered a plea of guilty to the entire indictment or part of the indictment, enter a plea of not responsible by reason of mental disease or defect, or to withdraw such plea, and in such event, the entire indictment as it existed at the time such plea was restored. And when is that? Before imposition of sentence.
All right. So can you ask me the very first one in this line again?
Okay. You want me to read those three in a row again?
Yeah.
220.60. A defendant who has entered a plea of not guilty to an indictment may, as a matter of right, withdraw such plea at any time before rendition of verdict and enter a plea of guilty to the entire indictment. A defendant who has entered a plea of not guilty also to the indictment, both with permission of the court and consent of the people, can withdraw such plea at any time before rendition of verdict again, and enter a plea of guilty to part of the indictment, or enter a plea of not responsible by reason of mental disease or defect to the indictment. At any time before sentence is imposed, before imposition of sentence, is that the same thing?
Mm-hmm.
Okay. The court may permit the defendant who has entered the plea of guilty to the entire indictment or part of the indictment, or a plea of not responsible by reason of mental disease or defect, to withdraw such plea, and in such event the entire indictment as it existed at the time of such plea is restored. And we finish that text. Next.
What's next? 260?
260, and it only has 3 questions, and one of them, and they're not really even questions. I'm just going to read them, okay?
All right.
It's about, every trial of an indictment must be a jury trial, except where the indictment charges the crime of what? The defendant may at any time before when waive a jury trial and consent to the jury trial without a jury. Except where the indictment charges what?
Murder in the first degree.
And the defendant may at any time before what waive the jury trial?
Selection of the jury?
Before trial.
Oh, so that's the same thing, because the jury trial commences with selection of the jury.
True, okay. So any time that the defendant may at any time before trial waive the jury trial. Okay. This is a true or false. A defendant must be personally present during the trial of an indictment, provided, however, that a defendant who conducts himself in so disorderly and disruptive a manner that his trial cannot be carried on with him in the courtroom may be removed from the courtroom if after he has been warned by the court that he will be removed if he continues to engage in such conduct.
Yep, this is one warning and then you can get kicked out.
Right. All right, I'm going to give you the order of the jury trial, and you're going to tell me if it's must or met.
Okay, well, you know what? I'm going to try. How about I try to tell you what it is?
Go right ahead.
Okay. So, the jury must be selected and sworn. The court must deliver preliminary instructions to the jury. The people must deliver an opening address to the jury. The defendant may deliver an opening address to the jury. The people must offer evidence in support of the charge. The defendant may offer evidence in his behalf. The people may offer evidence in rebuttal. The defendant may offer evidence in rebuttal. The court must, the defendant may make a summation. The people may make a summation. The court must deliver a charge to the jury. The jury must retire and deliberate and, if possible, render a verdict.
Done. We're up to 270.
Wow, that was it?
Yep, that was it.
Holy crap.
I'm getting so tired, though. It's already 11.
All right, so do you want to end at 270, or let's try to do 270.
All right, let's do 270 and then we quit, because 270 is a little lengthy.
Okay.
But let's do it. A jury, we should be able to blow through it, though. Just yell out the answers.
All right.
A jury trial consists of how many jurors of an indictment?
12.
But alternate jurors may be selected.
Yeah.
The panel from which the jury is drawn is formed and selected as prescribed by.
Judiciary law.
And the first, how many members of the panel that return from the thing to appear and their names are called?
12.
A challenge to the panel is an objection made to the entire panel of prospective trial jurors returned for the term and may be taken to such panel or to any additional panel that may be ordered by the court. Such challenge may be made only by
Defendant, and that has to be in writing.
and only on the grounds that there has been such a departure
From the judiciary law.
Okay. A challenge to the panel must be made before when?
Before selection begins.
Right. And if there is no challenge to the panel, such challenge is deemed to have been.
Waived.
Such challenge must be on the record or in writing.
In writing.
If the facts are denied by the people, witnesses may be called and examined by either party. All issues of fact and law arising on the challenge must be tried and determined by who?
The court.
And if a challenge to the panel is allowed, the court must what and what?
Discharge the panel and order a new panel.
Right. 270.15. If no challenge to the panel is made, or if such challenge is made or disallowed, the court shall direct the names of not less than how many members to be drawn?
12.
Such persons shall take their places in the jury box and shall immediately be sworn to answer truthfully questions relative to their qualifications. In its discretion, the court may require prospective jurors to complete a questionnaire concerning their ability to serve as fair and impartial jurors. Official form for such questionnaire shall be developed by who?
The fucking chief administrator?
Of the courts in the consultation with who?
Administrative boards of the courts.
Right, and a copy of the questionnaire completed by the members of the panel shall be given to the court and each attorney prior to when?
Prior to summations.
Examination of jurors.
Shit. That's what I should have said.
Okay. You'll say it the next time.
Okay.
Blank shall initiate the examination of prospective jurors.
The judge, the court.
The court shall permit both parties commencing with who to examine the prospective jurors.
The DA, people.
Right, and each shall be afforded a fair opportunity to question the prospective jurors as to their qualifications and stuff like that. 8. The court may, for good cause shown upon motion of who, issue a...
Protective order.
Right, and who is that a motion of? It could be either party
or the person.
Any affected person or the court. And such a good cause shall exist where the court determines that there is likelihood of A. Bribery, B. Jury tampering, C. Physical injury to the juror, D. Harassment to the juror.
All the above.
Right. 10. The court shall permit both parties commencing with the people to examine the prospective jurors individually or collectively regarding their qualifications to serve. Upon the completion of such examinations, both parties commencing with who? Both parties may challenge a prospective juror for cause.
People.
11. A challenge for cause is an objection to his prospective juror and may be made on the grounds that 1. He doesn't have the qualifications. 2. He has a bad state of mind that's likely to preclude him from rendering an impartial verdict. He's related 6 degrees of consanguinity or affinity. Do you want me to go into all those other things about a civil and...
Yeah, go for it.
You want me to read all of it? Okay.
Yeah, we should know it.
He's related within the 6 degrees by consanguinity or affinity to the defendant or person injured or to the prospective witness at the trial or to counsel for the people or the defendant, or that he is or was a party to party adverse to any such person in a civil action, or that he has complained against or been accused by any such person in a criminal action, or that he bears some other relationship to any such person of such nature, it is likely to preclude him from rendering an impartial verdict. Basically, some sort of relationship.
Yep.
He was the witness at the preliminary examination or before the grand jury, or he is to be a witness at the trial, or he served on the grand jury for which found the indictment or served on the jury trial, or the crime alleged may be punishable by death and the prospective juror entertains such consciousness that his opinions against or in favor of such punishment, he doesn't want, he can't do it. Because he has strong feelings about it.
Yeah.
All right, 270.15. If such challenge for cause is allowed, the prospective jurors must be what?
They have to be removed.
They must be
Discharged.
excluded from service.
Oh, excluded. Okay.
After both parties have had an opportunity to challenge for cause, the court must permit them to peremptory challenge any remaining prospective juror, and such juror must be excluded from service. The blank must exercise their peremptory challenges first and may not after
the people.
The respondent, the defendant, has exercised his blah blah blah. Okay. The process of the jury selection shall continue until how many persons are selected and sworn?
12.
The juror whose name was first drawn and called must be designated by the court as
the foreperson, and
no special oath needed to be administered. If before 12 jurors are sworn, a juror already sworn becomes unable to serve by reason of illness or incapacity, the court must him, and the selection of a jury must be completed.
Discharge him.
And the peremptory challenge is an objection to a prospective juror, which no reason need be assigned. Upon any peremptory challenge, the court must or may exclude the person challenged.
They must.
Right. Each party must be allowed the following peremptory challenges. Blank for regular jurors if the highest crime is an A felony.
20.
And how many for each alternate?
2 challenges for each alternate.
And if the class is the highest crime is a B or a C felony?
Only because I just went over it tonight. It's 15 and 2 for each alternate.
And the highest crime is in all of the cases?
All of the cases, it's 10. 10 for the regular jurors and 2 for each alternate.
Perfect.
And in regular lower criminal, it's 3 for each side plus 2 for each alternate.
3 for each side plus 2 for each alternate. Okay. When 2 or more defendants are tried jointly, the number of peremptory challenge is or is not multiplied by the number.
Not the same.
And immediately after the last trial juror is sworn, the court may, in its discretion, direct the selection of 1 or more, but not more than how many additional jurors?
6.
Right, to be known as alternate jurors, except in the prosecution for what the court may, in its discretion, direct the selection of as many alternate jurors as appropriate.
That's murder in the first.
Right. And alternate jurors must be drawn in the same manner, must have the same qualifications, must be subject to the same examinations and challenges for cause, and must take the same oath as the regular jurors. After the jury has retired to deliberate, the court must either, with the consent of the defendant and the people, discharge the alternate jurors or direct the alternate jurors to not discuss the case and must further direct that they be kept separate and apart from the regular jurors. True or false?
It's true.
Right. In any prosecution in which the people seek the sentence of what? The court shall not discharge the alternate jurors.
Death penalty, which
right.
They're not going to ask, don't worry.
Oh, they're not going to ask?
No, because, the death penalty, okay. It's unconstitutional.
Okay, I'll just move on then.
Yeah. Okay. You can leave it on your video if you want, but...
That's okay. If at any time after the jury has been sworn and before the rendition of a verdict, a juror is unable to continue serving by reason of illness or other incapacity, or the court finds that facts unknown at the time of the jury selection, the juror is grossly unqualified to serve in the case or has engaged in such misconduct of a substantial nature but not warranting the declaration of a mistrial, the court must order that the discharged juror be replaced by an alternate juror whose name was first drawn and called, provided, however, that if the jury has begun the deliberations, the blank must consent.
Defendant.
Right. Such consent must or may be in writing.
It must.
It must be signed by the defendant in person in open court in the presence of the court.
True.
Right. If the discharged juror is the foreperson, the court shall designate the new foreperson, the juror whose name was...
second drawn and called.
Right. And if no alternate juror is available, then what happens?
The court must declare a mistrial.
Right. 270-40. After the jury has been sworn in and before the people's opening address, the court must instruct the jury concerning its basic functions, duties, and conduct. Such instructions must include that the jurors, one, may not converse amongst themselves or with anyone else at the trial, about the trial, may not read or listen to any accounts or discussions of the case in newspapers or media. They may not visit or view the premises that's allegedly committed. And they may not, prior to discharge, they may not request, accept, agree to accept, or discuss with any person receiving or accepting any payment or benefit in consideration for supplying any information concerning the trial, and they must promptly report to the court any incidents within their knowledge involving an attempt by any person improperly to influence any member of the jury. 270-45. During the period from the time the jurors are sworn to the time they retire to deliberate upon the verdict, the court may, in its discretion, permit them to separate during what and what?
Recesses and adjournments.
Right. Or direct that they be continuously kept together during such period under supervision. You have a star next to this next question. When the court is of the opinion that viewing the premises will be helpful to the jury, the court may, in its discretion, at any time before what? What of the jury to be conducted to such premises? I remember it now.
Summations.
Before summations. In such case, the jury must be kept together throughout, under the supervision of the appropriate public servants appointed by the court, and the court itself must or may be present.
Must.
The prosecutor and the defendant and the counsel must or may be present.
May.
For the purpose of such an inspection is solely to
View.
permit visual observation by the jury of the premises in question. Neither the court, the parties, counsel, the juror may engage in discussion, argumentation concerning the significance of the implications of anything under observation or concerning any issue in the case. Case closed.
That's it?
That's it.
All right.